recognize the Honorable, the Minister of Justice and Correctional Services to introduce his budget vote. The Honorable Minister.
Honorable House Chair, Ministers and Deputy Ministers present, members of the Judiciary here present, honorable members, distinguished guests, comrades and friends, ladies and gentlemen. House Chairperson, it is a privilege of great distinction that I present to you the Budget Policy Statement of Vote 22 of the Department of Justice and Constitutional Development in this year of Oliver Reginald Tambo. Comrade Oliver Tambo always understood that the roots of apartheid had grown so deep that only an enduring and concerted effort would be required to disentangle our society from the trappings of centuries of legislated prejudice, inequality, and racism. The adoption of the Constitution on 8 May 1996 marked our freedom from the deep affliction of colonialism and apartheid, which was implanted in this country by colonial and apartheid regimes. The democratic Constitution sets us on a new path towards the reconstruction from the legacy of our past, and it is also a circumstance of happy augury for the budget vote debate of the Department of Justice and Constitutional Development, therefore, to be held in the month of May 2017, exactly 90 years since the birth of the late Comrade Duma Nokwe, former Secretary General of the African National Congress, who was the first black advocate of the Transvaal Supreme Court on 9 March 1956. This year, 2017, the department has adopted the theme code towards a transformed and accessible justice system for all as an embodiment of the objectives we are striving to realize. The mandate of the department straddles a number of departments and entities that constitute the justice family. In addition to its role of administering some 763 magistrates' courts countrywide, the department provides state legal services inclusive of both legal advisory and the management of litigation services for the entire government, as well as functions relating to services of the Master's Office. House Chairperson, despite the fiscal constraints our country is currently facing, we are optimistic that we'll be able to deliver on our broad mandate with the allocated budget totaling some 18.927 billion rands, for which we are grateful, and thanks in advance for the support we believe we will receive from yourselves this afternoon for this budget. The National Development Plan has crystallized the beacons for fundamental renewal of our country's legal system. As one of the pillars of the Renaissance Project, Cabinet in March this year approved a comprehensive framework for the development of an integrated criminal justice strategy, the ICJS, through which all departments and entities in the criminal justice value chain will integrate their efforts in order to strengthen the efficacy of the entire system. The envisaged strategy will go a long way towards addressing challenges relating to the management of bail, overcrowding in correctional centers, and the optimal use of alternative non-custodial sentences, which will alleviate the pressure being experienced by various departments and entities in the justice and crime prevention and security cluster. We will also, as part of the ICJS, strengthen the integrated justice system governance framework, the IJS, and the accountability arrangements relating to the transversal ICT platforms, which are meant to support the system. We're impelled to place the victim at the center of the criminal justice system in order to effectively combat the gruesome acts of violence that plague our society today. Sexual offenses courts provide specialized support services to victims of sexual offenses, decrease turnaround times, and improve conviction rates. This past Monday, Deputy Minister Jeffrey officially launched the 59th Sexual Offences Court in Thembalethu Magistrates Court, George, as part of this initiative. Honorable members, thank you. Honorable members, the crime of corruption, which is a global phenomenon, has participants across the private and public sectors of our society. This crime unduly enriches a few, undermines good governance and the rule of law, and ultimately impedes service delivery. As part of our overall fight against crime and corruption, I would like to state that the relationship between the JCPS cluster and the financial cluster is critical in combating money laundering, illicit financial flows, and terror financing. The Financial Intelligence Center Act made provision for the establishment of a counter-money laundering advisory council to be constituted by the heads of entities and directors general from both clusters. A disconcerting feature of the FICA Amendment Act recently passed by Parliament is that it does away with this all-important advisory council. The council would serve as an oversight accountability structure in relation to the functioning of the Financial Intelligence Center and would advise government on its endeavors in the fight against money laundering, illicit financial flows, and terror financing. It is important that future amendments address some of the overlaps that have been identified and shortcomings that needs to be improved upon. The asset forfeiture unit continues to be a critical part of the state's arsenal against this scourge and has delivered significant returns in the past few years, showing that crime does not pay. By end of March 2017, the AFU recorded recoveries in the amount of 685 million rands in respect of corruption cases involving 5 million rands or more, which is classified as government losses and proceeds of crime. These figures includes an achievement in respect of recoveries assets worth over 543 million rands from the property of a senior government official in the Department of Transport in KwaZulu-Natal. This recovery was the result of a collaborative effort by various departments that constitute the anti-corruption task team. As at 31 December 2016, the NPA maintained good conviction rates in all court platforms, recording 91% in the High Court, 80% in regional courts, and 95% in district courts. At this point, let me also allude to the letter addressed to me by the leader of the DA, Mr. Musi Maimani, recently urging me to put pressure on the National Prosecuting Authority to make a prosecutorial decision on the so-called Nkandla investigation. This request is oblivious of the fact that though I am enjoined by the Constitution to exercise final responsibility over the National Prosecuting Authority, as a cabinet member responsible for the administration of justice, this does not extend to interfering with the independence of that institution by encroaching on the exercise of its prosecutorial discretion. Would you rather I took the liberty to charge a handful of you for, amongst others, crimen injuria and criminal defamation for some of the utterances that you make almost on a daily basis without restraint? I will not take the temptation because I respect and love our Constitution. As at 31 December 2016, the NPA maintained good conviction rates in all courts. I think this is a repeater. Honorable members, as a further aspect of the Renaissance Project, we have identified the need to review the languages used in our courts with a view to enhancing the right of access to justice, defining the role of traditional courts and community courts to ensure that they offer qualitative alternative forms of access to justice, at which services are offered freely and expeditiously, promoting access to justice through the services of advice officers and the optimal use of paralegals. We will also, through the task team, which include the academic institutions and the legal profession, influence the review of the LLB curriculum in order to include African languages as part of the syllabus. We embrace the proposal by the Portfolio Committee on Justice and Correctional Services to co-host a conference from which we can harvest thoughts and views on these important themes with a view to accelerating the desired reforms. Honorable members, family law services of the department, including the services of the Master's Office, are central to the livelihood of the vulnerable members of society, especially children. Therefore, it is imperative that we continue to improve our services offering in this area of work. The introduction of the paperless estate administration system, the PEAS, in the Master's Office has enhanced the efficacy in the management of deceased estates and related services. The system has been rolled out to 15 Master's Offices countrywide, as well as approximately 206 service points in total. This has resulted in improved accountability and faster turnaround times. With regard to maintenance beneficiaries, we are encouraged to receive, the maintenance beneficiaries are encouraged to receive their maintenance payouts through bank accounts. Thus far, this initiative has yielded positive results. During the 2016-2017 financial year, for example, a total of 1.6 billion rands was paid to some 183,000 maintenance beneficiaries through the EFT system. We are also moving steadfastly in rolling out the rationalization of magisterial districts. We have, in March this year, for example, published notices on new magisterial districts in the Free State and Northern Cape provinces. And today, and the date of implementation will take effect after I have consulted with the Judicial Services Commission and after I have met in particular with the Chief Justice in this regard. People are able to access justice closer to where they live as a result. As we have committed ourselves in the annual performance plans, we will expand court-annexed mediation services to 30 courts in the current financial year. This is a new system that we have introduced to alleviate the long delays and waits for formal litigation to resolve civil disputes. Mediation only introduces a less adversarial system, but also cuts the costs associated with litigation. The construction of new courts and maintenance of our capital infrastructure is central to our quest to enhance access to justice. As I indicated during the debate of the OCJ budget vote yesterday, the construction of the magnificent seat of the Mpumalanga High Court in Mbombela is nearing completion. We will also be completing the construction of new magistrates' courts in Dimbaza, Eastern Cape, Mamelodi, Gauteng, Plettenberg Bay, Western Cape, and Port Shepstone Magistrates Office in KZN during the course of this financial year. We are looking at ways in which inmates who have been trained in artisan skills to be part of, which is part of their rehabilitation programs of the Department of Correctional Services, be involved in some of the identified minor works in the construction and maintenance of capital infrastructure projects. This project will alleviate pressure in our overstretched infrastructure budget at the department. We're transforming state legal services, the aim of which is twofold. Firstly, to enhance the efficiency and effectiveness of legal services rendered to government at all levels, and secondly, to use the system to expedite transformation within the profession and building capacity for inclusive participation in the profession, especially by those who were historically marginalized, notably Black people in general and women in particular. House Chairperson, I am pleased to inform this House, this Honorable House, that we have introduced a few bills of great significance in carrying out our mandate. Amongst this are the Traditional Courts Bill, which we have partially alluded to, the Prevention and Combating of Hate Crimes and Hate Speech Bill. The introduction of the Traditional Courts Bill brings us closer to the finalization of the long outstanding reform aimed at regulating the role and functions of traditional courts in accordance with the constitutional imperatives and values. I am heartened by the public response we received in respect of the Hate Crimes Bill, which are estimated at 40,000, inclusive of petitions.
Honourable Minister, you have 1 minute left.
I want to assure honourable members that all the comments received have been considered. We are also forging ahead with a national action plan to combat racism, racial discrimination, xenophobia, and related intolerances through the National Action Plan. As regards the Truth and Reconciliation Commission, I wish to report that the department has ensured that government policy reflects the redress required, taking account of the extent of the suffering of our nation. The department is finalizing the regulations on community rehabilitation in line with a decision by Cabinet under the supervision of the Interministerial Committee on People Empowerment Programs. Chairperson, allow me to once again commend the budget of the Department of Justice and Constitutional Development. The figures are before you, and I look forward to all the support. Thank you very much.
Thank you, Honorable Minister. The next speaker is the Honorable Mochecha. Honorable Member, you are not supposed to address members in the gallery or any officials that are attending the budget vote. It is against the rules. Continue, Honorable Mochecha.
Honorable House Chairperson, Honorable Minister, distinguished members, you will be pleased to hear that the ANC support this budget vote. From 2012 to date, the focus of the department shifted from transformation of the judiciary to the legal system as a whole. Our transformation process has been very slow and largely tinkered, rather than radically transformed the architecture and substance of the system. The desired radical transformation of the legal system cannot and will not be accomplished without addressing the root causes of injustice in South Africa. These root causes are racism and colonialism. The radical transformation requires the deracialization and decolonization of the entire legal system and the development of a progressive jurisprudence. The South African Constitution and the barriers to the realization of the values that underpin it will not be understood unless and until the spirit of racism and colonialism is unpacked and dealt with. In 1980, our icon, Oliver Reginald Tambo, told the World Council of Churches in Holland that racism was used to justify three inhumane policies. First, the dispossession of the land of African people and its natural resources. Secondly, the transformation of African people into instruments of labor for the benefit of the white minority. And thirdly, the imposition of white minority rule on the African majority. The defeat of African traditional rulers at the end of the 19th century enabled the racist Union of South Africa to destroy the traditional African kingship and queenship systems and replace them with the Governor General as the supreme chief of all African people, empowered to depose traditional rulers who resisted racism and colonialism and replace them with puppets of the colonial authorities. These arbitrary powers, which violated the African laws of succession based on royal or blue blood, and opened the door wide open for the divide and rule strategy as well as indirect rule. The architects of the Union of South Africa, Cecil John Rhodes and Lord Alfred Milner, were Freemasons, like some of us in this house, who believed that Africans were a subhuman race that is inferior to people of European stock. These two men were also leaders of the secret society that developed the British imperialist plan on which the Union of South Africa was constituted. This architecture of South Africa was rooted in racism from the outset. The authors of the British imperialist plan did not only destroy the African kinship system, but also the African moral and social fiber. The radical transformation of our legal system must include the revival of African spirituality and cultures based on the African humanist Ubuntu philosophy. The need for this African cultural renaissance appears in the genocidal philosophy of Lord Macaulay, contained in his address to the British Parliament on the 2nd February 1835. I quote, "I have traveled across the length and breadth of Africa, and I have not seen one person who is a beggar, who is a thief. Such wealth I have been seen in this country, such high moral values, people of such caliber, that I do not think we would ever conquer this country unless we break the very backbone of this nation, which is her spiritual and cultural heritage. And therefore, I propose that we replace her old and ancient education system, her culture, for if the Africans think that all that is foreign and English is good
Order,
and
honorable
greater
members.
than their own, they will lose their self-esteem, their native culture, and they will become what we want them, a duly dominated nation." On the 19th June 1913, the racist Union Parliament passed the Land Act number 27 of 1913, which allocated only 7% of the total surface of South Africa to Africans, leaving 93% to the white settler minority. Overcrowding and other social and economic pressures forced the colonial authorities to increase African land tenure to 13% of the total surface of South Africa. The dispossession of land and its natural resources degraded and dehumanized African people.
Honorable Chair, there's a point of order.
Sorry, Chair. Rule 68, relevance. I believe we are in justice and he's giving us a history lesson.
Justice.
No, I'm waiting to hear how it incorporates into this budget vote. So the member has 15 minutes, by the way.
Justice.
So you must just be tolerant.
Justice.
Continue, no, he's got 15 minutes. Continue, honorable member.
Justice is about the eradication of injustice. You can't eradicate injustice unless you know the roots of injustice. The dispossession of land and its natural resources degraded and dehumanized African people and deprived them of fundamental human rights and social justice. There is abundant evidence that the dispossession of land and its natural resources are the root causes of the deepening moral degeneration and the triple challenge of poverty, unemployment, and inequality. It follows from this that a radical transformation of the South African legal system cannot and will not be achieved without land redistribution and restitution of land to its rightful owners. Among other things, the Constitution guarantees the right to have disputes resolved by application of law decided in a fair public hearing before a court or tribunal, and vests judicial authority of the Republic in the courts, and envisages a competent, well-equipped judiciary able to undertake the task of adjudicating disputes. The Constitution also addresses the rights of arrested, detained, and accused persons, as well as the rights of freedom and security of persons. The transformation of the legal system focuses on access to the rights of the accused at the expense of civil rights, in particular, land claimants, land reform, and rural development. Hence, Many land claims lodged in 1998 have to date not been finalized or received any attention. The focus on accused persons loses sight of the fact that land dispossession and its abiding effects are the root causes of crime and the huge costs attendant upon the administration of courts and correctional centers. The rights of the accused and land claimants are equally important. Adequate legal assistance must be extended to land claimants just as it is given to accused persons. Access to land and its natural resources will not only overcome the socio-economic legacy of apartheid colonialism, but will also reduce the incidence of crime. The process of land redistribution and restitution is very slow and falls short of creating the risk of land invasions and violent protests as people get frustrated. This leads to arrests and overcrowding of our courts and correctional centers. The committee learned with dismay that available funds earmarked for land claimants are administered by private law firms that are naturally conflicted. The committee calls on the Minister of Justice to urgently engage with his counterpart, Minister of Rural Development and Land Reform, to ensure that these funds are transferred to Legal Aid South Africa, which is efficient and effective. The committee strongly supports that Legal Aid South Africa, chaired by Judge President Dustin Mulambo, should administer all legal aid funds, and that if its budget should be increased to enable it to deal with land claims. The current legislation does not allow permanent appointment of judges to the Land Claims Court. The Land Restitution Act also favors landowners rather than land claimants. We urge the Minister of Justice to urgently engage his counterpart, Minister of Rural Development, to amend the Land Restitution Act, which has created huge bureaucracy in the form of regional land claims commissions and provided burdensome criteria for the validation of land claims. No wonder that the majority of land claims lodged in 1998 have not yet been finalized. The Community Property Association Act further complicates the bureaucratic processes governing the land restitution process. The CPA Act must also be reviewed in the light of land dispossession and wars of resistance waged by the kings of queens of this country. The question of communal land tenure has not yet received the attention it deserves. The destruction of the kingship and queenship systems by the apartheid colonial system disrupted and distorted well-functioning traditional courts systems which were accessible and delivered justice speedily and cheaply. For that reason, Honorable Minister, we want to commend you for intervening swiftly and making sure that this act is brought to this court. We are, however, perturbed by the request by NEDLEC that the deliberation of that bill be delayed. But Honorable Minister, on your part, you have done the necessary and we appreciate that. These delays in dealing with the traditional courts bill is again concerning us because we have called for community courts, and Honorable Minister, you responded swiftly and you confirmed that this afternoon. And we are looking forward to receiving a bill on community courts. Currently, the role of paralegals is constrained by the lack of statutory recognition. The Legal Aid Practice Act has not dealt with this matter, and it appears that the legal profession wants to dictate the pace of transformation, and that we will not agree to. We want to ensure, Honorable Minister, with your continued support, that when we deal with the amendments to these acts, we revisit the question of paralegals legislation and their statutory recognition. Honorable Minister, you have also correctly observed and acted that in the same manner that when you and I studied law, English, Afrikaans, and Latin were compulsory, why should indigenous African languages not be compulsory now? Why should we have judges, prosecutors, magistrates, and all these people who cannot speak the languages spoken by the majority of the people? If there's no communication between the masses of the people and the lawyers, what justice can we deliver, Honorable Minister? So we support your intervention. Honorable Minister, we also agree with you that the law schools must not be asked for permission whether or not they must include indigenous languages. They must be ordered. We are ready to make the necessary legislation to that end. Again, Honorable Minister, we cannot have a situation where our kids are told to be unemployable graduates. They are unemployable because universities teach them theory. They need to establish university
Honourable
legal
member,
aid centers to
Your
make
time
sure.
is now expired.
Thank you, Honorable Chairperson.
Thank you, Honourable Member. The next speaker is the Honourable Breitenbach.
Honourable
Order,
Chairperson,
Honourable Members. Order.
Honourable Chairperson, Honourable Members, a year has passed since we were last here debating the budget vote of 21. I wish I could say that things have changed for the better, that the same tired old issues do not require being highlighted here today, but unfortunately this is not the position. In fact, despite the best efforts of the Minister to portray improvement, and despite the thin veneer of varnish that the ANC members will try to apply to these issues, little to no progress has been made on critical issues, and in some instances the regress in performance has continued. This Chairperson and Honourable Members must be attributed to the lackadaisical and ineffective approach of the Minister and his Deputy. A Minister that is not able to understand and consequently convince his Cabinet colleagues that the administration of justice is a labour-intensive exercise and therefore should not be subject to the same budget cuts as other departments that may not necessarily render a critical service is obviously a poor leader. Our sympathy therefore must lie with the rank and file within the department and its various entities, who must continue to render these essential services in the face of budgetary constraints and must also contend with vacuous political leadership. It is astonishing that the Minister is always ready, willing and able to operate in the political space, but rarely in the last 3 years has he been able to garner the necessary energy to perform his executive functions. Let me substantiate this by discussing the
Member.
following.
Can I please request that the
Honourable
speakers...
Minister, can you rise for your intervention, please? Why are you rising?
May I request the speaker that she speaks clearly because she's addressing herself to me and I can't hear half of what she's saying. It's the request. Thank you.
Sit here by me.
Continue, Honourable Member.
Thank you. Let me substantiate
Now, you see, Honourable
this.
Members, if you make noise in between, it makes it even more difficult for the Honourable Minister to hear what the member says. So can we just keep the levels down a bit, please? Continue, Honourable Member.
Let me substantiate
And it will
this.
assist us also if your own members don't interrupt you, Honourable Breitenbach. Continue, Honourable Breitenbach.
Thank you. Let me substantiate this by discussing the following areas of grave concern within this budget vote. The Minister is responsible, inter alia, for the appointment of Masters of the High Courts and the administration of the Guardians Fund and deceased and insolvent estates. It is no secret, and I'm sure it's in fact common cause, that all the officers of the Masters of the High Courts are in a state of abysmal shambles. What is also of concern is the perceived unwillingness to implement a system to address service delivery complaints of the public in respect of these officers. It is of no use whatsoever for members of the public who have grievances about the administration of estates to lodge complaints with the institution responsible for the shambles. Since 2014, we have advocated for some form of internal ombud to deal with these complaints, and the only response has been an annual promise that the department is looking into it. Perhaps the Minister thinks he can address this issue once he has solved the multitude of problems in respect of the proposed policy in respect of insolvency practitioners, which has been found to be unconstitutional by both the Western Cape High Court and the Supreme Court of Appeal. This, of course, should come as no surprise, as the Minister and his deputy have laid bare for all to see their rather poor understanding of our Constitution. Honourable members, cast your minds back to the debates on the Public Protector's report on Nkandla, and more specifically, whether the remedial action ordered by the Public Protector is binding, or the debate on government's failure to arrest Omar al-Bashir, during which Minister Masuta and Deputy Minister Jeffrey respectively advanced arguments later held by our courts to be without any basis in law, and more specifically constitutional law. While we certainly don't want to speculate whether these failures can only be ascribed to a poor understanding of the law, or whether these arguments were motivated by political grovelling for the benefit of the hand that feeds them, one would ironically hope that the latter is the case, as it gives some explanation for the fact that the Minister and his deputy both seem to have a rather flimsy grasp on legal principles. The next area of grave concern is the National Prosecuting Authority. The Minister, when it suits him, is quick to remind us that he, in terms of the Constitution, is the Minister responsible for the administration of justice and the National Prosecuting Authority. However, what we have seen since 2014 is a Minister in a constant state of dithering in respect of the problems facing the management structures of the NPA. At least a constant state of dithering whenever those in upper structures of the NPA captured by President Zuma and his henchmen are under scrutiny. His unwillingness to deal with Mkhwebi and Jiba hiding behind appeals they have lodged to justify why they are on stay-at-home pay, well in excess of R1 million annually each year. His failure to accept the findings of the retired Constitutional Court giant, Justice Zak Yaqub, in respect of the mayhem reigning at the NPA head office. Juxtapose this, however, with his sudden burst of energy and his personal involvement in the collapsing of the Kassam inquiry into the fitness of Mkhize Nkosana to hold office, as well as his alleged involvement, along with the ubiquitous Michael Halley, in negotiations of the notorious and putative settlement agreement reached with Nkosana. The picture is thus completed of a minister who is responsible for the NPA and its functionality only when it suits him. Chairperson and honourable members, obviously, I will again be accused today of debating while embittered about my own involvement with the NPA. But before I'm again so accused, I leave you with the following to underscore that the Minister's inability to focus on what is important has had the following knock-on effects since 2014. The number of cases finalized with a verdict has decreased between 2014 and 2016 by 1,598 in the regional courts and by 6,735 in the district courts. The response of the department and the Minister to this is that they removed this indicator from the 2017-2018 annual performance plan. Simultaneously, the number of cases on the backlog court roll in the district courts has increased by 2,352 over the same period. The response to this is a smoke and mirrors approach with a formula to be applied to determine whether cases qualify to be included on the backlog roll being changed from year to year. Also bear in mind that it is under the watch of this Minister that the NPA has now been allowed to significantly lower many of its performance targets and remove others completely from its annual performance plan, proving to us all that while the Minister has time to meet with the new NDPP on a Monday afternoon at Luthuli House, despite the fact of a long-standing and apparently vital and much-anticipated dental appointment, to discuss what they described as the anarchy caused by students, he apparently has not yet found the time to inform the NDPP that whilst the latter must certainly focus on eliminating political opponents, he should still ensure that the NPA also does its day job efficiently. And then in closing, Mr. Minister, I feel constrained to point out to you that a request to you to inquire about a 2.5-year-old decision that is outstanding about the 783 counts of corruption against the President hardly equates to asking you to interfere in the prosecution process. The National Director must do his job. You must see to it that he does it. South African citizens are entitled to require you to do so. I thank you.
The next speaker is the Honourable Matiase.
House Chair, the Department of Justice and Constitutional Development and many of its entities have in the last few years been used to fight political battles of the ANC and more recently the Gupa faction of the ANC, whilst at the same time failing short of their constitutional mandate, often because resources are used to fight these battles instead of being used to prosecute criminals. The entities falling under this department, the NPA, State Legal Services, the Legal Aid South Africa, SUI, SIU RADA, court services, including Chapter 9 institutions, designed to support our democratic dispensation, such as the Human Rights and Public Protector's Office, have been run down, and the ANC has been using all this time to erode the autonomy of these institutions so that they become useless lapdogs of the looting, stealing, ruling elite of the ANC. There are two tasks the challenges which faces this department. That of political interference, patronage and incompetency, and corruption. The levels of maladministration and incompetency are so obvious such that we see poor levels of performance. And at the end of the third quarter of 2016-17, the department reported that it had achieved 68% of its intended targets. We do acknowledge that some of these targets were not met because the judicial services in the courts are grossly underfunded. Yet we have a government that continues to steal while cutting the department's budget by 1.36% and the court services budget by 2.59%. We don't find it surprising that the only budget increase for the department is for state legal services, since the state is consistently and constantly having to defend corrupt officials and its president in the courts, and uses its budget as a slush fund for this purpose. The NPA and some certain sections of the judiciary must be named and shamed for those who decided not to grant bail to Boginkosi Kanyile, which was overruled by the Crown Court at 250 rand bail, with the Chief Justice himself having to say, I quote, "People who are accused of rape get bail. People who are accused of murder get bail." What is it about this one? This statement calls to question a presumption that some judicial officers are impartial in adjudicating disputes. What is of serious concern to us is that there's a need to be given urgent attention to such concerns as we raise them now, that 23 years into a democratic dispensation, the judiciary still remains largely untransformed in terms of race and gender. The ANC is engaged in internal bickering when it led the transformation of the judiciary and the justice services at its own device. This has direct consequences at the levels of the levels of lack of transformation in the judicial and criminal justice system. The truth is, the daunting task that faces all of us is that the courtroom must be transformed, and it should be transformed to reflect the demographics of a society. Would want also to remind all and sundry that the framework for transformation of the state legal services need to be elaborated on and properly executed to ensure transformation is prioritized. Additionally, all judges and magistrates must go through an extensive training to deal with sexual abuses and rape cases in delicate and sensitive manner, especially where it involves minors. We urgently call for an immediate re-establishment of sexual offenses courts countrywide. Lastly, over the last 2 decades, the ANC has effectively used the judiciary as its site of struggle for political power and hegemony. This, like any other site, remains a contested terrain. It will find us ready, and we shall never retreat in fighting, even from this site. Honorable Motshekga has spent a lot of his time in this speech lamenting about what the psalmist once lamented about. And I quote, "We get our own bread at the risk of our lives because of the sword in the wilderness." Honorable Motshekga and the entire benches of the ANC, you have abandoned the most fundamental task of the revolutionary movement, which is to transform the judiciary, the justice criminal system, and the society as a whole. Instead, you've spent much of your time
Honorable
in
member,
internal
your
party
time is now
political behavior.
expired.
And I want to warn you and warn the ANC that history will judge
Honorable
you
member,
harshly.
your time is expired.
Thank you.
The next speaker is the Honorable Msimang. Order, honorable members. Order, honorable members. Continue, honorable
Thank you,
member.
Honorable Chair. In the present times, that is 23 years into our democracy, the buzzword in the Department of Justice and Constitutional Development is transformation. While it is noted that such transformation is happening within a context of dire financial straits, the fact is, it is an imperative, given the central position of the department as an instrument of securing justice by addressing inequalities and divisions in our society. Admittedly, the department has a very broad scope and many entities, all which should receive attention. But this presentation will focus only on transformation, which will improve access to justice, particularly by Black citizens of this country. Of primary consideration in this regard is the promulgation of the revised Traditional Courts Bill. This bill was introduced to Parliament some 10 years ago, and it is regrettable that it still has not yet been passed. Is this a demonstration of the low regard with which the institution of traditional leadership is held in this country? How so, when this institution plus the concomitant African customary law are entrenched in the Constitution? It is often argued that those who are opposed to this bill do so on grounds that it discriminates against women. How could that be possible when the Constitution categorically prescribes that no law which is in conflict with the Constitution shall be valid? How so when the institution itself embraces women as members of the institution, where a number of those that qualify have been inaugurated as traditional leaders? Furthermore, the IFP is concerned that African customary law remains largely unwritten and uncodified. It remains only in the memory of certain elders whose survival is threatened by attrition. It is accordingly possible that when people turn to applying it, they will find that there are few or no reliable sources on the tenets of this law. Another essential transformation is the introduction of African languages in court. Besides the fact that they are entrenched as official languages in the Constitution, they are also spoken by a majority of citizens of the land. While we respect the position of the judiciary that English should be the language of the record in our courts, we still argue that for Africans to access justice via the medium of an interpreter is not ideal. I was accordingly grateful, Honorable Chair, to hear the Minister address this subject in some detail in his address. Granted, the development of African languages as media of the court is dependent also on the cooperation of other government departments such as arts and culture, where structures such as PENSALB should develop the necessary terminologies. Also, the Department of Education should insist on making the teaching and learning of African languages compulsory in our school. The IFP supports this budget. I thank you, Honorable Chair.
Thank you, Honorable Member. The next speaker is Honorable Mwabe.
Thank you, Honorable Chairperson of the session, honorable members, Minister, Deputy Ministers, the distinguished guests in the gallery and the leadership of the judiciary present. The Department of Justice and Constitutional Development forms the backbone of the judiciary in South Africa. For the bulk of legal matters affecting ordinary citizens are dealt with in lower courts. It is therefore a paramount importance that a transformation be expedited in order to ensure that effect is given to our fundamental right to equality before the law. Transformation in the legal profession is very important to ensure justice for all, and even more pressing is the need for transformation in our criminal justice system. In particular, the NFP is heartened by the department's intended emphasis to be placed on a victim-centered approach as part of its transformation momentum, because there is a perception among our people that the law favors the perpetrators of crime in our existing criminal justice system. The intended focus of the department's spending of its 16.9 billion budget for 2017-2018 and over the medium term, as outlined in the report of the Portfolio Committee, is also encouraging and generally reflects the prioritization prevalent in the department's planning. Whereas the department is commended for adjusting to budgetary constraints, the NFP shares the observation and concerns expressed by the Portfolio Committee. In particular, we are concerned about the slow pace which land claims are settled. Land restitution or the lack thereof is fast becoming a dangerous flashpoint in the political arena, which has a potential to tear apart the social fabric of South Africa if not addressed with urgency it deserves. We therefore add our voice to the recommendation of the Portfolio Committee that the department expedite the process by engaging with the Department of Rural Development and Land Reform on the transfer of funds allocated to support legal advice and litigation by land claimants to Legal Aid South Africa, so that it can take on these matters in the interest of national social cohesion. Another concern which the NFP has is impact of funding constraints on the rollout of properly capacitated and dedicated sexual offences court. Barely a day goes without horrific sexual offences making headlines in our media, especially the merciless killing of women and girl child in particular. And the public is fast losing confidence in the justice system to combat this scourge, giving rise to violent forms of community reprisals, which ultimately undermines the rule of law. It is therefore imperative, Chair, that the department should rise to the challenge with a renewed vigor, working within the budgetary constraints to ensure that the rollout of sexual offences courts be prioritized. The NFP supports this budget. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Deputy Minister of Justice and Correctional Services, responsible for justice and constitutional development.
Thank you, Chairperson. Honourable members, guests in the gallery, I see a number of regional court presidents, chief magistrates, regional heads of the Department of Justice, and other senior officials of the Department of Justice, and some members of the Human Rights Commission. I hope I haven't missed anyone out. Last week we heard about the tragic deaths of Karabo Mokoena and 3-year-old Courtney Peters. Over the weekend, we heard of Lerato Malloy, an openly lesbian woman who was stoned to death in Soweto. And there are others. Since the beginning of the year, we've lost Stasha Arendser, 11, raped and killed. Mananki Anna Boys, 28, stabbed in her body birth. Jeanette Trindi, 34, 5 months pregnant, raped, killed and burnt. Mavis Mabala, 25, her body was found hidden in a bush. Nosipho Mandleleni, 24, shamboked to death. Stembile Mdluli, 37, murdered. Macy Molife, 36, murdered, doused with paraffin and set alight. Akona Njokana, 31, shot dead. Bongeka Pungula, 28, body found in Kladi with gunshot wounds to her head. Nicola Pina, 28, murdered, unborn fetus cut from the body. Poppy Kwabe, 24, body found in Naledi on Friday. Tapelo Ramorotong, 26, killed and burnt. Renee Tracy Roman, 13, half-naked body found near her Lavender Hill home. Priska Skalk, 28, stabbed to death. Yapa Yamile, 6, mutilated body was discovered stuffed in a plastic bag in a toilet in Kailicha, 3 blocks from her home. And Maximo and Octavia Yella, 3-year-old twins, found murdered in Hout Bay. These are the names we know, and there are no doubt others. Each and every victim is somebody's child, and most of them, it seems, were killed by persons close to them or known to them. From the side of government, and particularly as a parent, I want to offer our heartfelt condolences to these families. We can do whatever we can to ensure that the perpetrators are prosecuted. But however, we cannot have a police officer protecting every person who has a family violence interdict. We cannot guard every young child 24/7. We are not there in people's homes behind closed doors where many of these crimes happen. But we can and must change attitudes. We must send the message that partner abuse and violence against women and children is unacceptable. We must look at the way we raise our sons and boy children in our communities. What do we teach them? Do we teach them that women are not their possessions which they can destroy if they're angry with them? As for young men, what type of support do we give them so that they do not one day explode in a violent rage of pent-up emotions? Our department runs a number of programs to combat domestic violence, intimate femicide, and gender-based and sexual violence, which time unfortunately doesn't allow me to elaborate on. We have 55 Tutuzela care centers which provide medical and psychological services to victims of sexual violence in one location, while statements are taken and evidence is gathered for the criminal case. Nearly 33,000 matters were reported at the 55 TCC sites. In the last financial year, these care centers, 33,000 in the last financial year, 15-16. These care centers are a best practice model and a pride of our country and should be extended to all victims of gender-based violence. We also then, the Minister referred to the sexual offences courts, just to say that we are on track with the rollout in terms of the targets that have been set and now entering the second phase of the rollout. We will also be engaging relevant government departments and civil society organizations with a view to sharpening and strengthening our implementation of the Sexual Offences Act. The fight against these forms of violence is one we must win. We cannot rest until we've won the battle. To paraphrase Bob Marley, the people who were trying to make this world worse are not taking the day off. Why should we? It's extremely important that we work with stakeholders such as NGOs and community-based organizations, and we will be engaging with them and other stakeholders in this regard. And on the issue of stakeholder engagement, it's a vital element of our department's work, and we feel it is paying off. We've had some success on the reformulated Traditional Courts Bill with a reference group of government, traditional leaders, and civil society coming out with a more acceptable version of the bill. We had a similar approach, although not as extensive, on the cybercrime bill with a reference group of various stakeholders, which helped us a great deal. Our National Task Team on LGBTI rights also consists of various government departments, the NPA, SAPs, and civil society bodies. The NTT was named in a 2016 report of the UN's Office of the High Commissioner on Human Rights as a best practice model and an international case study. The NTT continues its efforts to counter the continued discrimination based on sexual orientation and gender identity against members of the LGBTI community. The chairperson and members of the newly established information regulator were appointed by the President for a 5-year period with effect from the 1st of December 2016. No thanks to the DA. The regulator has many functions to perform. It doesn't only enforce compliance, it also has a supervisory function. It must provide education by promoting an understanding and acceptance of the conditions for the lawful processing of personal information, and must monitor and enforce compliance by public and private bodies with the provisions of the Protection of Personal Information Act. We wish the information regulator well in fulfilling its mandate and look forward to the full implementation of the Protection of Personal Information Act. Legal Aid South Africa continues to make access to justice a reality for poor and vulnerable groups. Legal Aid South Africa has a court coverage plan which ensures that legal representation is available at every criminal court in the country through their 128 offices countrywide, thus ensuring that all accused persons that qualify for legal aid are able to exercise their constitutional rights to a fair trial in terms of criminal and civil matters. Due to high demand and limited budget, the Civil Law Service is prioritized for mainly constitutional rights matters, with a focus on women, children, and vulnerable groups. In addition, Legal Aid South Africa has a national legal advice line which members of the public can access toll-free in order to obtain legal advice as required. The Justice Portfolio Committee has expressed a concern at the slow pace with which land claims are being settled. We're engaging our colleagues in rural development and land reform regarding the possibility of Legal Aid South Africa assisting land claimants, subject to us finding funding for this. An option would be transferring some funding to Legal Aid South Africa. Legal Aid can similarly also assist in the enforcement of ESTA rights, subject to available funding. Chairperson, we've greatly improved our compliance with international treaties and reporting. In terms of our treating obligations, we must report to the UN and African Commission on Human and People's Rights on a regular basis. And in this regard, we reported in April on the African Charter on Human and People's Rights and the Protocol to the African Charter on the Rights of Women. In August, to the International Convention on the Elimination of All Forms of Racial Discrimination, and more recently, last week, to the United Nations Human Rights Council on our Universal Periodic Review. We've also submitted our initial report indicating progress since South Africa's accession to the International Covenant on Economic, Social and Cultural Rights. Chairperson, we've reached our target of 100% rollout in respect of small claims courts. There are, at the end of the 2016-17 financial year, 405 small claims courts covering all magisterial districts and sub-districts nationally, with another 19 additional places gazetted at places of sitting of these courts. At present, we have 1,921 commissioners presiding in the courts and 2,090 advisory board members supporting these courts. The establishment of small claims courts with at least one in each magisterial district and sub-districts in South Africa is a major step forward in terms of enhancing access to justice. Since 2009, we've established 217 small claims courts. That's 53% of the total number. And the aim, as honourable members should know, of small claims courts is to improve access to justice and make civil justice inexpensive and accessible to those who can't afford litigation in the ordinary civil courts and whose claims do not exceed 15,000 rand. I want to sincerely thank every commissioner who offers his or her time and expertise free of charge to render this valuable service to the public. Also, a word of thanks to the advisory board members and court staff who ensure that these courts operate optimally. We're currently working on a comprehensive review of the Small Claims Court Act, which is a 1984 Act and thus predates the Constitution. In addition, this financial year, we're focusing on improving the functioning of their courts and the advisory boards. We're now also extending small claims courts to branch courts so as to continue with our quest for access to justice. 3 new small claims courts for Colenso, Warden and Stainsrus have been approved since the 1st of April this year and will be gazetted before the end of the month. The sheriff's profession continues to play a very important role in the administration of justice, more especially in civil matters. They are the arm that basically enforces judgments of the civil courts. The rationalization and demarcation of magisterial districts within municipalities has also impacted on the service areas of sheriffs, as they're appointed for an area of the high or lower courts within a magisterial district. Generally, where there's been changes in magisterial court demarcation, sheriffs will keep their original demarcation even if it doesn't follow the new area, as they can't be disadvantaged without their consent. And the change to the sheriff's demarcation will be made when the office becomes vacant. Most sheriffs are appointed for a magisterial district, and in the rural or smaller towns, you'll find a sheriff will be appointed to a number of offices, as a single office is often not economically viable. often skewed along racial lines. As part of the demarcation process, and if one of these offices becomes vacant, the department will investigate and recommend a more equal division of sheriff's areas. We have, for example, embarked on this process in Johannesburg, Randburg, which includes Midrand, and Port Elizabeth, and the department gazetted the redescription of these and other areas in Gauteng and the Eastern Cape for it to take effect on the 1st of June this year. The same process is underway in other provinces. I'm pleased to inform the House that sheriff areas in Gauteng that have been vacant for a number of years due to, amongst others, the rationalization process will be filled with effect from the 1st of September 2019. Honourable members, the justice portfolio is really about having an accountable justice system, a justice system which responds to the needs of all our people, where all people can go for assistance and enforce their rights. It's also about rendering quality service to the public and stakeholders. As O.R. Tambo said in June 1985 when he delivered his report to the National Executive Committee, on the National Executive Committee to the National Consultative Conference of the African National Congress in Kabwe, Zambia, and he said, we have to be in daily contact with our people. We must constantly ensure that we work better and do more so that members of the public know where to go. When we take up their issues, they must know they will be responded to and they will be assisted. I'd like to express our condolences on the passing of Nomboniso Nangu, the leader of NADCAO, the National Alliance for the Development of Community Advice Officers. I worked closely with Nomboniso, who was a true embodiment of what an activist should be. Our wish is that NADCAO continues her legacy and good work in assisting our communities. This morning we learned from the Gauteng Regional Court President of the passing of Ms. Zelda Moletsane, a regional magistrate in Johannesburg. Ms. Molotsane was appointed as one of the first group of presiding officers of the divorce court after democracy, prior to its integration into the regional court in 2008. We convey our sincere condolences to her family, the judiciary, and her friends. Chairperson, our work is dedicated to the public, the mothers claiming their maintenance at the courts, the witnesses testifying in court, the victims of crime, the litigants in civil court, as they are truly the reason for our existence and enable us to do what we do. We have to be in daily contact with our people. We have to create a society where all our people are and feel safe. Just in the remaining time to respond to a few issues, the Honourable Horn yesterday managed to equate a debate on judicial overreach with committing a crime. But we've heard again from the DA here that we can do nothing right as the government, as the ANC government. But whereas we thank the Inkatha Freedom Party and the NFP for their support in the budget and the positive points that they have raised where we need to receive attention. As far as the EFF,
Honourable
I've tried
Deputy
hard
Minister,
to...
your time is now expired.
Okay.
Thank you. The next speaker is the Honourable Mahila.
Honourable Chairperson, Honourable House Chairperson, Honourable Minister, Honourable Deputy Minister, Honourable Members, the Director General of the Department of Justice and Constitutional Development, distinguished guests, Maafrika Borwa Matle, Toel. I wish to focus on one branch of the Department of Justice and Constitutional Development which deals with the interests of the most vulnerable in our society, the Master's Office as a tool of enhancing access to justice. The Master's Office is mandated to deliver 5 specific services to the public, which are the regulation and supervision of the administration of deceased estates by ensuring the orderly winding up of the financial affairs of the deceased and the protection of financial interests of the heirs. Legal Aid South Africa has signed a cooperation of agreement with the Master's Office undertaken to assist in the administration of deceased estates where minor heirs are concerned. The regulation and supervision of the administration of insolvent estates through liquidations and sequestrations. The administration of the Guardians Fund, which is created to hold and administer funds which are paid to persons, including minors, persons incapable of managing their own affairs, and untrained persons. It's safe to mention that money which remain unclaimed in this fund for 30 years and is forfeited to the state. The registration and supervision of trusts, appointment and supervision of curators, tutors, and administrators for the protection of legally incapacitated persons. There are 15 master's offices located in all the high courts spread throughout the 9 provinces of the country. These offices render all the services that I alluded to earlier on, except administration of the Guardian Fund, which is currently offered in only 6 of the 15 offices. The Master's Office has increased its footprint by affirming magistrate courts as service points. 402 of the 756 magistrates courts serve as service points for the Master's Office with regard to administration of deceased estates. Services in the Master's Office are improving with time. A total of 271,984 cases were finalized by the Master of the High Court in the 2015-2016 financial year. The department has rolled out the paperless estate administration system, PEACE, in all the 15 Master's Offices and 96 service points, and the rollout is continuing. The Master's Office has developed an integrated system with the Department of Home Affairs, which allows the Master's Office to extract details of a deceased person directly from the database of Home Affairs without hindrance. The successful implementation of PEACE has led to improved case management. It has relieved work pressure on officials, and it has kept fraud. The system has put a stop to the loss of documents. The system computerizes the administration process. All documents are scanned and stored. The Master's branch officials have hosted several radio talk shows to create a general awareness on the Master's services. Outreach events targeting remote and poor areas have also been hosted. It is imperative that the services provided by the Master of the High Court should be known and accessed by the majority of the people in the country. Unlike the gloomy picture which was painted by Honorable Breitenbach, this is an indication of a government at work. This is an indication of a government that needs to be given a renewed mandate. The renewed mandate in 2019 with 2/3 majority. The DA has lost its space as a political party. It spends time in court, it does not spend time with the people. The DA is imploding. The white caucus of the DA is imploding. The white caucus of the DA is composed of verkramptes who wants to reverse this country back into apartheid. The black caucus of the DA is composed of verlegtes who want to see constitutional democracy working. The unfortunate part is the white caucus of the DA is in charge. And therefore the DA can never take this country
On a
forward.
point of order, Chair. Honorable Maila. Honorable Maila. Can you
Chair,
pause a little bit? There is a
I'm
member
rising
raising.
on Rule 68. What the honorable member is discussing, that it's irrelevant in terms of what it's supposed to be discussing.
It got nothing to do with the Justice Department. Honorable member, let's go back to the fact that he's still debating. Let us hear him out. What is it going to say?
Obviously,
continue, Honorable
obviously
Member.
she's not talking her mind. She's obviously not talking her mind. She's protecting the master.
Point to order.
Can you pause, Honorable Maile? Honorable members, order. Order, honorable members. Chief Whip of the Opposition.
Thank you very much, House Chairperson.
Honorable members,
I'm really struggling to hear you over the harridan that's shouting on the left here, I'm afraid. House Chairperson, we've had several rulings in this House around racial stereotyping and using and classifying people on racial basis. Sorry, I'm really struggling to hear you, Chair. The harridan won't stop speaking. It's your job to protect me as well. I know I'm from the DA, but it's your job to protect me as well.
Honorable members from both sides. On my right, can you be quiet? And also on my left, you cannot, it's unparliamentary. You cannot use the words of breathalyzers and so forth in the House. So it's also unparliamentary. Can we give the Speaker on the podium a hearing? Yes, Honorable
House
Chief Whip
Chairperson,
of the
so
Opposition.
the point I'm making to you is that there have
Yes.
been a number of rulings about racial stereotyping. And the use of racial stereotypes has been ruled unparliamentary in this House. And the annotated digest of rulings has 3 such rulings where the presiding officer said that racial stereotyping is not ever acceptable in this House, or to call people a racist, it's never parliamentary. And so I would ask that you ask the honourable member to withdraw the comments he's made about so-called white caucus and black caucus.
Honorable
No
member.
such caucuses exist. They may exist in the ANC caucus, although they've got very few white members. So
Honourable
it's hard
member.
to work out. But nonetheless, it's unparliamentary, and I ask you to rule on that matter.
Honorable member, what is unparliamentary? It's when the member calls another member a racist. In this time, he did not refer to any member a racist. But in the same manner, that is what we have said right now, honorable member, that it might apply to another party, of which I think you have used the same statement as the member have used. So he has never called anyone a racist. You may continue, honorable member. That one is not unparliamentary.
Yes.
House
Thank you very
Chairperson.
much.
Are you the presiding officer, or is this lady in pink here the presiding officer? House Chairperson, so what you're saying is that racial stereotyping is now permitted in the Parliament of the Republic of South Africa?
I never
Is that
said
your
that,
ruling?
honorable member.
that your-
I said the member has not called anyone a racist.
Instead, he
a
said members of the DA,
House.
which are us. We members of the DA.
It's fine,
We
honorable
somebody.
member. I will check on the hand side. I will come back with that ruling if ever it's a matter. You may continue, honorable member.
House Chair,
Yes, ma'am.
well, I rise on a point of order
Yes, member.
on 2 grounds. Firstly, to allow a member to proceed without retracting his utterances.
But I've ruled on
Orders,
that, honorable member.
orders, can you be patient a minute?
Yes.
Orders on racial polarization. Orders on racial polarization. Secondly,
Yes.
the ANC must admit that unlike them,
Honorable member, the second
This is
point
the last point.
not,
This is the
but
last
it's
point.
not a point of order, honorable member. You are just making a statement and you
I'm rising
understand
on a
very
point for
well.
you. Let me speak after making my point and then make your ruling.
But honorable
Let me
member, you
speak,
know it's
And
unparliamentary.
after speaking, make your ruling, right?
Honorable member, you said you are rising on a point of order. The
Yes.
second point is not a point of order.
No,
you
this is
know.
point of order.
It's not.
The ANC must be humble to admit that there is some efforts on the part of the DA to
Honorable
integrate
member,
and to fulfill the mission
honorable member,
of national cohesion
take your seat,
and racial
please, honorable
integration,
member.
a task which the ANC has failed to
please
perform.
take your seat,
Must be humble
honorable
enough
member.
to admit that reality. It's a
Please take
truth.
your seat, honorable member. Even on the first point that you have raised, honorable member, I've ruled on that. Honorable Maile, you may continue with your debate.
Thank you, Chairperson. What I'm saying is not a myth. It will be very difficult to deal with Mrs. Helen Zille for embracing colonialism, because she's a member of the White Caucus, and the White Caucus is in charge. So how do you charge Helen Zille when she's in charge? Thank you very much.
Thank you very much, Honorable Maile. I now call upon Honorable Mulder.
Honourable Chairperson, this afternoon we are debating this afternoon the budget vote for justice and constitutional development. Now the fact is, if you look at the total budget, you'll find that it makes provision for 18.9 billion rand, and of that a mere 80 million, 0.4%, are allocated for constitutional development. So constitutional development is not a very high priority with this department. However, if you look at the sub-program, constitutional development, then you'll find that the task of the department with regard to constitutional development is the following: to promote the Constitution and its values, assists and protects independent institutions supporting democracy, to ensure their independence and their effectiveness. What I would like to know from the Minister is what the department did when the party of the ANC were coming with one attack after the other on the office of the Public Protector. Because it's your task in terms of your own program to protect those institutions. Did you do that? What did you do? I would like to know. The second point I would like to make, Honourable Chairperson, is that this afternoon when the Honourable Minister referred to the letter he received from the Honourable Leader of the Opposition, Musi Maimane, the Minister went out of his way to convince us of the fact that he cannot intervene because the NPA is independent and he should not get involved in that kind of approach. And that was his reaction. He was cheered very loudly, very loudly. The most enthusiastic member who cheered that point of view was the Honourable Charlotte Pilane Mayake, right there behind him, and she's going to participate in the debate later today. Now you see, the problem is this. In this very same chamber, on the 5th of November last year, when the Justice Committee was interacting with the National Prosecuting Authority, that honourable member made the following point, and I quote, she said the following with regard to the NPA. She said, I quote, "Working for the NPA means that you are in government. It actually means you are rolling out the mandate of the ANC." Unquote. When I confronted the honourable member in the House with that statement, she denied that she said that. We can show the honourable member the clip on television. Those were the exact words. Now, what I would like to know...
On a point of order, Honourable Chairperson.
Honourable Mulder, can you pause? Yes, Honourable Machege.
I think I'm being misrepresented. And why you actually want to bring this discussion in this vote, this budget vote, because it's irrelevant.
Can you
that
come
had
up with
to
the
do
point of
with
order, please?
the office of the NPA and withdrawal of the charges, which of course
Honourable
you didn't want
Machege,
to
that
sort
is not
out.
a point of order. We are now discussing the matter. Can you continue, Honourable Mulder?
In Afrikaans sê ons 'n benoude kat maak benoude spronge. The fact of the matter is, Honourable Chairperson, that honourable member made those allegations. Now I want to know from the honourable Minister. Minister, is that the point of view of your department, that the NPA's task is to roll out the mandate of the ANC? Or is your point of departure and your point of view that this institution should act without favour, without prejudice, and without whatever interference there may be from the department or from anybody? Because it's the view of that member who will speak this afternoon, and if you want to deny that those were your words, we can bring that to the House and whoever want to see that. That is your point of view. The last point I would like to make, Honourable Chairperson, the last point I would like to make...
Thank you very much, Honourable Mulder. Your time is exhausted. I now call upon Honourable Carter.
Thank you, Chairperson. Chairperson, what if Mr. Zuma, the NPA, 50 billion rand and state capture have in common? We all know that when the NPA, with much fanfare by Sean Abrams, maliciously and with a total disregard for the law, charged then Minister Gordhan and others for fraud, 50 billion was wiped off the JSE. When society mobilized and the Helen Suzman Foundation and Freedom Under Law made application to the courts, Abrams backtracked and announced the withdrawal of the charges, washing his hands of a decision to prosecute. But as the HSF and FUL put it in court papers, and I quote, "The only reason inference to be drawn is that the charges were being pursued for purposes other than those set forth in the NPA Act, and that the NPA were being abused, had been captured or unduly influenced by third parties, were acting irrationally, arbitrarily, or for ulterior purpose and the political or financial gain of others, and were acting in a manner inconsistent with their mandates." As Minister Gordon at the time said, this is a moment when all South Africans need to ask, in whose interest are the people in the Hawks, the NPA, the NDPP advancing? Where do they get their political instruction from and for what purpose? But the Honourable Mulder, I suppose, just gave us the answer. I trust that the Minister will proffer an explanation. Honourable Gordon subsequently called on all South Africans to connect the dots. Well, in this particular saga, when our illegitimate president was forced to go through the motions of considering the possible suspension of a NDPP pending an inquiry into their fitness for office or face judicial scrutiny, Mr. Zuma eventually advised he could not find any evidence that the conduct of Advocate Abrams was motivated by ulterior or improper motive, which would give rise to a charge of misconduct, or that he was no longer fit and proper to hold office. Well, we all know that in the intervening period and under the darkness of night, Mr. Zuma pushed the junk button by irrationally removing Minister Gordon and Deputy Minister Jonas. To paraphrase former Deputy Minister Jonas, if you connect the dots, there are certain patterns that point to a particular interest being protected, being consolidated.
Thank you
and
very
being
much,
deepened.
Honourable Carter.
No.
Your time is
Sorry,
exhausted.
There's my time. I've got a minute left.
No, Honourable
I've
Carter,
got
you
a
are not the
minute
time
left.
speaker. You
I've
are
got
speaking.
4 minutes.
I rely on the
I
table,
have
Honourable
4
Carter.
minutes.
Your time is exhausted.
It was agreed I have 4 minutes.
It's 3 minutes.
I can advance more than 783
I rely on
reasons
the desk,
as to
Honourable
why the
Carter. Your time
NPA
is
can be
Order.
considered to be
Order,
captured,
Chairperson.
including the
The time is up.
stonewalling. My time is not up. I've got 4 minutes. Here is my clock. Here is my clock. I can advance more than 783 reasons as to why the NPA can be considered to be captured, including the stonewalling of every attempt made by civil society, organizations, and
Point of
opposition
order.
parties to gain access to the
Point
so-called
of order.
spy tapes and to review the Zuma decision. The delay in deciding whether or not...
Can I intervene just a bit? Can you just hold on? There is a point of order that has been raised.
Yes, Chairperson, I rise on Rule 69C, which talks to undermining the authority of the presiding officer. The member has been asked to leave because her time is up and she's not...
That is not a point of order.
Chairperson,
Honourable Carter, can you wait a little bit? Can I explain this? The front table has just indicated, because we rely on them when it comes to the issues of time, that the time is exhausted, because what is written here is 3 minutes. But as you have seen, I've been checking with them. They are rectifying the issue. So I am allowing the honourable member to take 1 minute more, of which he has already started to work on it. So there was nothing. There is 3 minutes on the list, and I've checked with the table, so they are rectifying the matter.
Chairperson.
Thank you very much. You may
Chairperson.
continue then, Honourable
Sorry,
Carter.
Chair, I just want to
Where
respond.
is the
Point of order, yeah.
Yes, Honourable Singh.
Chairperson, I trust that the members of the table would not make this serious mistake again. 3 is written in a particular way and 4 a different way. It's here on this list. 4 minutes. And I trust that Hansard would not delete whatever the member has said after the 1 minute, after you said the time has expired.
I humbly apologize for the table, that it won't happen again. We have talked about it. You may finish then, Honorable Carter.
Chairperson.
Thank you, Chairperson.
Sorry, Honourable Carter.
I can advance
Honourable
more than
Carter,
700
just hold on. Chairperson.
Yes,
you
Honourable
can't
Member.
penalise Honourable Carter and say she can just have the last few seconds. You've got to give her a full minute. That was the agreement.
Honourable
yes,
Member.
The ANC members are howling over her. We couldn't hear
Honourable
a word
Member.
she was saying.
We are going to give Honourable Carter a moment to
full minute.
finish. Yes, that is
Thank
what
you
I've
very
said.
much. So you've got a full minute.
That is what I've said, Honourable Member. Honourable Carter, you may continue with your speech.
Thank you, Chairperson. I can advance more than 783 reasons as to why the NPA can be considered to be captured, including the stonewalling of every attempt made by civil society organizations and opposition parties to gain access to the so-called spy tapes and to review Zuma's decision. The delay in deciding whether or not to prosecute Mr. Zuma with corruption in respect of Nkandla. The decision not to institute criminal proceedings against 3 officials implicated in the SIU report on Nkandla. The resignation of Gerrie Nel to set up what is effectively a parallel prosecuting, and I will say it, an independent system. Mr. Minister, you preside over an NPA that has been captured, and you, your president, and the ANC is complicit therein. 23 years of our democracy, and in the 20th year of our constitution, we would never have thought that we
Honourable
would
Carter, can you
ever...
pause a little bit? There is a point of order that has been called.
I'm rising on Rule 84. The member is insinuating that the minister is complicit in the undermining of the NPA. It is unparliamentary.
Point of debate.
It is unparliamentary. Thank you.
Honourable Member, a point of order has been raised as to say you are complicating that the minister is complacent. What are you saying on that? The point of order has been raised.
The point I've raised. I'll read it to you. The minister, you preside over an NPA that has been captured. And you, your president, and the ANC are complicit therein, because if they don't do anything, they are complicit. And previously, you have said that it is a matter of debate when other people raised rules of orders.
Honourable Khatema.
On Rule 85, it is very clear that if she must come with a substantive motion to raise the issue that the minister is complicit in undermining the NPA.
Thank you very much, Honourable Khatebe.
Point of order, Madam House Chair.
Can I still finish on the one that has been
On
raised?
that point of order.
Can I finish on the point of
You're
order
gonna
that has been
You're
raised?
going to rule, so it's going to make my point obsolete then, if that's the case.
Come again?
You're going to make a ruling and then you're not going to want to listen to what I've said. I want
Yes,
to
there is a point of order that has been raised.
I
Let
want
me
to
finish
intervene
with
on
it,
that
then I
point
come to you.
I want to intervene on that point of order.
But there is no point on a point,
There's
Honourable
a
Member.
very important point on the point of order.
Can I finish with that one? Can you allow me to finish on the
Well, I
point
know
of
what
order
you're
that
gonna
has been
do,
raised?
so-
Honourable Member,
You
the
know
point
what?
of order has been
Chair,
raised and it
yeah,
is
Chair,
sustained.
you know what?
must come up
I
with
will-
a substantive
I will
motion on
withdraw
that
the
one.
fact
No.
that on the minister, but I will not withdraw it on the rest of the sentence. But on the
You
minister,
are withdrawing on
I
the
would
minister.
withdraw it.
Thank you very much,
Okay.
Honourable Member. Yes,
Just
Honourable Chief Whip of the
23
Opposition.
Madam House Chairperson, the Constitution of the Republic of South Africa and our rules confer upon members of this House, in terms of Rule 63 and 63, 1, 2, and 3, freedom of speech in this House. And they do that so that we can have a robust political debate where people are able to put forward their views, opinions, and argument. And I would submit to you that the Honourable Whip of the ANC has been overly sensitive in this matter. We can't have a full and frank discussion, and the Constitution wouldn't have prescribed freedom of speech for members in this House if we weren't able to put our political points across. Yes, I hear the Honourable Jeffries choping in about subject to the rules. I would say to you that what the Honourable Carter said is part of political debate. It's not a personal attack on the minister's integrity or anything like that. It is a part of the political debate. It's her political point of view. And if we're going to turn this parliament into a schoolroom where you can't say anything, we might as well not be here having this debate.
Thank you very much, Honorable Steenhuisen, but unfortunately, on the point that you are raising on, Honorable Carter has already withdrawn as he has directed to the Minister. You may continue then, Honorable Carter, and finish your speech.
Like I've said, 23 years of our democracy, and in the 20th year of celebrating our Constitution.
Then, Honorable
South
Carter,
Africa-
your time has been exhausted.
When I was stopped,
Your time is exhausted.
I had
Thank you
18
very much, Honorable Carter.
we would never have believed
Your
that we would
time is
ever take the
exhausted,
words of
Honorable
Madiba in saying that when the ANC do to you what the apartheid government did to you,
Carter.
then you must do to the ANC what you did to the apartheid government.
Chairperson.
Let me call upon Honorable Swart.
Chairperson, I'd wanted to ask the Honourable Carter if she'd take a question, and the question
Honourable
was
Deputy-
going to be
Honorable
in whether
Deputy
ever
Minister,
any
he's
elections
already
in
gone.
Coke.
Honorable Deputy Minister, Honorable Carter is done, so let us not even raise that. Honorable Carter, Honorable Swart. you may-
Chairperson.
Yeah, I've checked. You have got 4 minutes. Thank you.
Thank you, Chairperson, just for confirming the 4 minutes. Ministers, guests in the gallery, thank you for being here. And from the ACDP side, we fully appreciate the budgetary constraints under which the department and various institutions act. And we see on a day-to-day basis how thousands of magistrates, prosecutors, legal aid practitioners, court officials are doing their very best to uphold justice, and we commend you for that. There is, however, a very clear need to enhance, and some would even say restore credibility in our civil and criminal justice system. Now, we know the most important and efficient deterrent to crime is the sure knowledge that an offender will be speedily apprehended and prosecuted and sentenced to a lengthy period of imprisonment. Deputy Minister Jeffries mentioned a series of scandalous murders that have happened throughout the country. And how is it that we here in the Western Cape alone, 19 children have been murdered since the beginning of this year? 3-year-old Courtney Peters being the most recent tragic victim. And the Khayelitsha community appears to be hardest hit by the spate of murders, but which happen here and across the country. And so we too offer our heartfelt condolences to the families. And in this regard, the police are to be commended, as well as the prosecutorial services, for the speedy apprehension and prosecution of a number of the alleged perpetrators in these cases. 12 of the 19 cases are already before court. However, given the state of society, we need to introspect, not only amongst leadership, but upon every citizen of society. We need to have a look at ourselves, and we need to have an RDP of the soul. We need revival. We need reformation. We need self-governance and self-control. And clearly the church has a very key role to play in this regard. And we commend the many prayer groups and the more than 1 million South Africans that gathered recently to pray for our nation in Bloemfontein. But, honorable members, Chairperson, there's a growing deficit in society. And I know the members of the Justice Committee will share the sentiment. We've expressed the sentiments about state capture. This department is at the forefront, should be, of the fight against corruption in our nation. And state capture at this stage is the biggest source of mistrust between the government and the people. And trust can only be restored by taking decisive action based on prima facie evidence already available. Now, I raised this issue with the Public Protector, with the SIU Advocate Matiba, who is here. And whilst we're fully aware that the Public Protector's findings are subject to review, there is nothing to prevent the institution of investigations and criminal action at this time. Indeed, criminal complaints have been laid, and we would look forward to the speedy finalization of the investigations and the prosecution should it warrant. Unlike we saw with the former Finance Minister Pravin Gordhan, where it was done very speedily. And how difficult can it be to investigate a simple allegation that was made by former Deputy Finance Minister Jonas? Yes, so we would like to see prosecutions in this regard, but from the ACDP side, we support this budget vote. I thank you.
I now call upon Honorable Bongo, and let me clarify this. Let me clarify this, honorable members. 1 minute has been added to Honorable Bongo. So you'll take 7 minutes. Thank you.
Thank you very much, House Chair. Honorable Minister, Advocate Masuta, Honorable Deputy Minister John Jeffries, the DG of the Department of Justice and Constitutional Development, the Director of National Director of Prosecutions, Sean Abrams, Advocate Mutibi, the head of the Special Investigating Unit, honorable members and fellow South Africans, good evening. Despite the removal of many apartheid laws from the statute books, their repercussions continue to define the South African social and economic landscape. Poverty and inequality remain to be a major challenge to our country, where currently approximately 10% of the population owns about 42% of the wealth in this country. As the ANC government seeks to ensure the radical economic transformation to reduce the levels of poverty, inequality, and unemployment, it is important to note that we need to fight those existing and evolving threats of the economic development of this country. Some of the threats include, inter alia, illicit financial flows, corruption, which is not only in the public sector, but is as well as in the private sector, illicit mining of precious metals, theft of ferrous and non-ferrous metal, wildfire crimes, and cyber crimes. More than 80 billion rand is estimated to be leaving South Africa border to foreign jurisdiction in illicit financial flows on an annual basis. South Africa is ranked number 7 in the world in terms of volumes of illicit financial flow from developing and middle-income countries. Internationally, the majority of illicit financial flows are estimated to be as a result of tax evasion of some kind. About 5% as a result of theft and public resources, 35% is related to criminal activities. In 2016, South Africa investigators identified new patterns of illicit money flows as a significant increase of cash seizures in our port of entry. Greater collaboration and cooperation is needed amongst government agencies and private institutions to cap this scourge. It is for this reason that the National Public Authority reported that it has a plan to engage the private sector to improve detection and reporting of illicit money flows in the country. The work of the NPA in fighting economic crimes will also increase with the recent coming in force of Section 73, capital letter A of the Competition Act, Act 89 of 1998. This act introduced, among others, severe penalties for those who are dealing with these crimes and who are dealing with the collusions, cartels, and cartels conduct, such as price fixing, market division, and rigging. This conduct squeezes out the small players, and it hampers the entry of young entrepreneurs and black business people in the space because of the conduct that they're doing. As part of the contribution to fight and transform the economy, the Competition Commission has now, being in collaboration, has entered into Memorandum of Understanding with the Hawks and the National Prosecuting Authority to make sure that we are beginning to deal with this crime severely. We expect the NPA and the Commission to work together to make sure that they protect the sovereignty of this country. Special Investigating Unit Head, Advocate Mutibo, has reported to the committee that there are a lot of investigations that they are dealing with, particularly on the crimes that are committed by the private sector. In this case, the culprits are the big five contraction company who were involved in the 2010 scandal. And secondly is the banks that were found by the Competition Coalition to be dealing with some wrongful doing and corruption issues. The advocate has reported to the committee that as we stand, as of the 31st of March, government institutions are owing about 418 million to the SIU, and that hampers the work that must be done by the SIU. But since President Zuma has taken over office, we have, His Excellency President Zuma has signed over about 31 proclamations to make sure that we are able to deal with issues of crime, both in the public sector and in the private sector. Honorable members, there are issues that have been raised by some members of the opposition and so on. The African National Congress needs a constructive opposition to deal with it, to assist us to improve the policies, to improve the better life of the people of South Africa, not the noise that is being made this side. Like recently, they are going to court to say they want to protect members of the ANC from protecting the ANC from themselves. But what honorable members don't know, that in the DA, half of the Black Caucus is going to vote with us in the secret ballot. And in the EFF, we have 9 of them who are going to vote with us should the court grant the issue of the secret ballot. So the secret ballot, we must not look at it from the ANC perspective. Look at the issue of the secret ballot from the whole house of 400 members. The NFP is already with us, and other parties are with us. Then Black Caucus, we have half of it, 9 from the EFF. Then you can count the numbers.
Thank you very much, Honorable Bongo. Your time is exhausted.
To you is that we need a constructive
Thank you so
criticism
much,
from
Honorable
you.
Bongo. Your time is up.
Okay.
Thank you.
The ANC support this budget vote. Thank you very much.
Honorable Hon.
Chairperson, firstly allow me to add our voice to that of the Minister, his deputy and other colleagues who expressed their disgust here today regarding the horrific violence we are seeing in communities throughout the country against women, children, and members of the LGBTI. We agree that as a nation we must unite in saying enough is enough, and unite in sending out the message that these crimes are not reflective of the society our Constitution dreams of. But Chair, in this regard, allow me to plead with the Minister and his deputy that the proposal in the Judicial Matters Amendment Bill currently before the committee, that in future partially do away with dedicated sexual offences courts, must then rather be shelved. If we are really serious with the fight against these offences, we should listen to the statistics and the experts which indicate that much higher conviction rates are achieved when these cases are tried in dedicated courts. Chairperson, despite all of the protestations of the ANC and the nitpicking of the Minister in respect of the few areas of good performance in respect of Vote 21, there's unfortunately no denying that bar Legal Aid South Africa, the performance of this department and other institutions in the vote, if evaluated in totality, is going nowhere slowly. Chair, but before turning to the role of the Minister and his deputy in this backward slide, allow me at this point to briefly turn to one of our Chapter 9 institutions and confirm that our fear remains that the standards set by Advocate Madam Sella in respect of an unwavering commitment to our Constitution and effective handling of complaints of maladministration and corruption, specifically in respect of the so-called high-profile cases, will not be maintained in the next 6 years. Although in all fairness, Chair, no evidence is yet available to assess this in finality, as no findings in respect of any high-profile cases has been released since the incumbent took office 7 months ago. Chair, but as oppositions should do, let's return to the failures of the minister and his deputy. Unfortunately, their performance over the last 3 years in critical respects is best described by the words failure and delay. From the delay in the tabling of the legal aid regulations to the delay, or maybe it should be the failure, to table the regulations enabling the implementation of the Maintenance Amendment Act, passed nearly 2 years ago already by this House, with a big hoo-ha, indicating that government was to get tough on maintenance defaulters and blacklist them. Non-payment, with all respect, Deputy Minister, which in many instances is also a form of abuse, and which has not been enabled yet for the lack of regulations. Chairperson, to the delay in the processing of the cybersecurity bill before its eventual tabling, while the number of convictions for cybercrimes are sliding backwards and in the face of a massive worldwide increase in cyber attacks and crimes. To the inordinate delay in the appointment of the Solicitor General, which, Minister, you promised would happen, and I quote, very soon, in your 2015 budget speech, and which, if kept, surely would have eased some of the ills still faced by the state legal services, despite money being thrown at this problem, as if the Minister himself is able to print it. Yet, Chair, and ironically so, we have again today heard a lot about transformation of a radical kind. That's going to happen not only in respect of the economy, but also our legal system. This is ironic, Chair, because of the way the study, which should have been the launch pad of this radical transformation, a study into the socio-economic impact of the decisions of our highest courts, has been dealt with by this ministry. This impact assessment, finally completed, first announced in 2012, finally completed after yet some more delays at a cost of 12 million rand, has been with the minister since last year. But when asked for an explanation on why this report has not been tabled yet, all sorts of vagaries are proffered. From saying that the report is not final yet, to an answer that Cabinet is still processing it. It's clear there's no urgency to table it. Chair, radical transformation will not be launched from this pad, as the report in all likelihood have found that our courts have played a positive and enabling, dare we say radical role, in respect of the realization of socio-economic rights, and is not to blame for the failures of government to deliver in this respect. What would have been funny, if not sad, is that the APP of the department this year attempted to bury this report under a newly formulated target that in response to the report, a policy on the future court administration model of our high courts will be finalized this year. The latter, of course, being yet another of those issues the minister is approaching with his special mixture of obfuscation and tardiness. When the absurdity of this new target was pointed out during the budget briefings in March, a promise was made that an erratum to the APP would be tabled. To no one's surprise, this has also been delayed. And then, Chair, the delay of delays. Although in all fairness, this delay will serve as proof that the ministry is not yet the sole champion of delays. In this instance, it was aided and abetted by the Speaker. As we approach the 10-year anniversary of the so-called Kader Asmal report, which proposed that a single human rights watchdog be set up in South Africa, we woke up on Sunday last to advertisements in the newspapers informing the nation that we now have 7 days to comment on this report, after Parliament sat on it for nearly 10 years. 7 days after a delay of 10 years. Honourable Minister, please tell us, is that fair?
Honourable Juan, thank you very much. I now call upon Honourable Pilani Machege.
On a point of order, Chairperson, before we proceed, Honourable Horn just said the standard maintained by Advocate Madonsela cannot be attained in the next 6 years, casting aspersions on the performance of the current public protector. And I'm stating in accordance with Rule 88, that is about reflections upon judges and certain other holders of public office. The rule reads, no member may reflect upon the competence or integrity of a judge of a superior court, the holder of a public office in a state institution supporting constitutional democracy referred to in section 194 of the Constitution, or any other holder of an office. I wish to request that he withdraw the statement.
Honorable Member, thank you very much. I hear your point of order, but according to the rules again, when you want to raise a point of order, you raise it immediately so that the member can withdraw. So now the member is already out, but it's just a warning, honorable members, as we move forward. Let us refrain from having such statements. Can I call you to come to the podium then, Honorable Pilani Machege?
Honorable Chairperson, honorable members of Parliament, members of the executive present here today, Deputy Minister Makwetla, Deputy Minister Jeffries, Minister Masuta, senior management of the department here present today, the heads of the Chapter 9 institutions, South African Human Rights Commission, public protector that are here today, and the judges present here today. And Honorable Horn, I must actually say, regardless of the fact that maybe the timing of the point of order was actually delayed, you must have heard what I said. It's out of order for you to want to reflect upon this, a state institution. And the same thing is what was actually done by Honorable Breitenbach. She goes on to try and say and give the public an impression that the master's office is in shambles. But luckily, Honorable Maila came from the ANC to really help you to understand systems that have been developed for that office. That office is now running efficiently. Of course, we have corrected, like the finances of the Department of Justice, we have corrected the historical mess that was created by the apartheid system. Even that master's office, you still think that is the way you used to know it. You go and see how the master's office operates, you will actually get shocked. And then again, Honorable Breitenbach, you've got this scoop about Nkandla. We're here talking about the vote for the Department of Justice, and you're going on and on about Nkandla. Probably you must have gained something out of just saying Nkandla, even where it's irrelevant and unnecessary. Let alone the fact that you keep on bringing the spooks of NPA that you brought to Parliament. At every point you are mentioning the names, maybe it's best to go back to NPA so that you can go and close the record, so that we can be in the position to handle business in Parliament in a very sane manner. Honorable Matthias of the EFF, your imaginary government that is continuing to steal. Look what is behind me. I've got NPA, I've got Special Investigation Unit, I've got the Director General of the Department of Justice, who's actually responsible for the judiciary and all these processes. And if you could look further on, you'll see that there is a chairperson of the Portfolio Committee for Police responsible for the Hawks iPad. And now you want to tell us that corruption is a problem in South Africa, then you are actually telling us that all of these institutions are useless, we must just shut down business. The point I'm actually making to you is that there need to come time where we actually consciously deal with business that will develop South Africans and stop shouting corruption, corruption, corruption at every point, because we can deal with corruption in South Africa. We don't need a song called corruption. That is just a waste of time.
Can you pause, Honorable Member? Honorable Mhlongo, what's the point of order?
No, Madam Chair,
Honorable members, can we not drown the speaker, please?
I wonder.
Honorable members, can I protect you, Honorable Mhlongo? Honorable members, can we behave, please, Honorable
May I be
Mhlongo?
protected, Madam Chair?
Yes, I'm protecting you.
Thank you very much.
Thank you. You may proceed.
May I know if the Honorable Speaker is willing to take a question from EFF?
You're wasting my time. I want to speak and finish. No, I'm not willing to take a session, not for now.
You may continue,
And maybe
Madam
one
Chair.
other point that I actually just need to make, which is a sad point, is really for us to be serious about business. Look at what's happening in the Western Cape with all these children, 19 children that have actually been murdered and killed in the Western Cape. You're busy with civil matters and the communities are suffering because at every point, every day, you are at the doorstep of the court, but you're not fighting crime. Let's continue to fight crime against women and children and stop using courts for political battles.
On a point of order,
Honorable Majege, can you pause a little bit? Yes, Honorable Walters.
Chairperson, the honourable member is misleading the House. She knows, I'll tell you why. She knows that justice and police are a national competency, not a provincial competency. So it's the
Honourable
ANC
member?
government that is failing the
Can't hear
children
you,
of the
please
Western
talk
Cape.
loud.
Member, please,
Can't
you
hear
cannot
you.
rise and debate. Please, Honorable Member.
As I said, Chairperson, I said the honourable member is misleading the House because justice and police are a national competency, not a provincial
Member,
competency.
that is the point of discussion.
No, no,
Can we
no, it's a
allow the
fact.
Honorable
It's
Member
a
to
fact.
continue? Please,
It's a fact.
Honorable Member.
So if anyone is,
Honourable Member.
betraying the children of the Western Cape, it's the ANC government.
Honorable Majege, can you continue?
Like I said yesterday, freedom of, the new form of oppression
Chairperson.
is to try and make people to look like they don't know what they're talking about, to make them
Honourable
controversial.
Majege,
It's a
can you
new form of
pause?
oppression.
Can
And
you
you
pause,
think freedom of
Honourable
speech is
Majege?
about you only.
Yes, Honorable Carter.
Chairperson,
Honorable Carter.
Chairperson, why is it?
Honorable members, please, can we not shout to this level? We are drowning the speakers, and it's difficult even for the minister to hear what the honorable members are saying. Yes, Honorable Carter?
Thank you, Chair. Chair, why is it that it's always a point of debate when it is for ANC, but it always needs to be withdrawn if it's someone else? Justice is a national competency.
No, Honorable Carter, I don't think what you are raising is correct. It's not even a point of order. May you continue, Honorable Majek.
Thank you, Chairperson. It's because they think it's themselves who have the right to speak. Even this whole thing about freedom of speech is about themselves, me, and I. When in actual fact, freedom of speech is supposed to be subject to rules. And freedom of speech is not about provocation, because this is what you do. All the time you keep on provoking, testing on the kind of reaction that you can actually turn around and criticize, calling it freedom of expression. It's not going to help build peace in South Africa. And if you're serious about peace in South Africa and development of South Africa, you will stop it here and now.
Honorable Majek, can you pose a little bit? Yes, Honorable Member.
Can I please
Can
be
we
protected?
listen, honorable members? Yes, what is your point of, what point are you rising on?
As Honorable Majake represent the ANC of Oliver Tambo.
No, what point
This
are
claim
you
that she's making.
rising on, honorable member?
Does she represent the ANC of Oliver Tambo?
Do you want her to take a question?
This is not the ANC
Honorable
of Oliver Tambo.
Majege, he's requesting you, if he's asking if you can take a question?
We'll talk about it outside.
Okay,
Let me tell you, you can continue to want to steal the legacy of the ANC as the opposition, and you will think it will make you smarter. I'm ANC, and therefore, the legacy of ANC
On
is
a
mine.
point of order, Chairperson. On a point of order, Chairperson.
Yes, honorable member, what's
We
your
will
point
never
of-
steal something from
Okay,
you that will
honorable-
steal from the examples of Oliver Tambo.
Can you pause?
Lulu,
I can't
of
even
Sisulu,
hear your
not
point
from
of
you.
order, honorable
I can
member.
hardly hear you because
But
you are
you're
making
screaming.
noise.
Honorable Majege, please don't
You're
respond.
screaming. The
Honorable member,
Majeka,
can
the
I?
point of order,
Can you,
Chairperson.
can you stop for a while? Honorable members, I can't even hear the point of order that the member is raising. Can you please? Honorable members, can we please behave? Can we please behave in a parliamentary manner? What's your point of order, honorable member?
Thank you, Honorable Chairperson. But you know, I will never follow an example of the ANC, of that ANC. I will follow an example of Oliver Tambo, not of that ANC of Zuma.
No,
So
no, no.
Honorable Majeka must stop screaming. and she
Honorable
must
member,
stop- she
that
must
is
use
not
the
a point of
example
order.
Jacob Zuma.
Honorable member, that
Not
is not a point of
our
order.
Tambo.
Let us allow Honorable Majege to continue, please.
Thank you, Honorable Chairperson. The committee's observations are that The committee repeats its concern at the slow pace with which land claims are settled, apartheid dispossessed people of the land, and resources leading to poverty and inequality. In the committee's view, the process of dealing with land claims is falling short, like Honorable Muteka has actually indicated, creating the risk of land occupations and violent protests as people become more and more frustrated. The ANC is serious about allocating land to the people, but the ANC is totally against unlawful land occupations advocated for by the DA alliance partner, the EFF. The committee knows that the ministry's intention is to engage with its counterparts in the rural development and land reform regarding the feasibility of transferring the budget to provide legal assistance to land claimants.
Honorable Pilane Majege, unfortunately your time is up. Can I then now call upon...
The ANC supports the vote.
Can I call the Minister of Justice to come to the podium, please?
Chairperson, honorable members, all our special guests in the gallery, officials from the department, including the leadership of the various institutions, notably the Director General of the department, the head of the SIU, the head of the National Prosecuting Authority, and all other institutions within the justice portfolio. Let me not only acknowledge your presence here, but express profound appreciation for the tireless, selfless contribution that you continue to make to ensure that our justice system works. And in particular, let me also recognize a very important pillar represented here of our constitutional democracy, namely the judiciary, in the form of the different magistrates, leaders within the magistracy from the different quotas within that institution. And of course, in order to ensure that I do not, at the expiry of my time, miss out on this opportunity, I would like to thank Mr. Enver Daniels and Mr. Basson, both of whom retired from the public service recently, for the contribution they made in the administration of justice in South Africa. Now, colleagues, as usual, the debate today was vibrant. It was vibrant because there are issues of contention that underpin our justice system in general, and in particular, more broadly, our constitutional democracy. This is a commonplace of exchange of ideas, contestation of ideas, and the vibrancy reflects that this is at the heart of the democracy which our country and our constitution has ushered in 1994. But let me from the very onset indicate that so much has been said about state capture. Well, let's continue to talk about it. But in doing so, let's deal with the matter holistically. Let's take it from where it starts. 1652.
Order, honorable members.
365.
Honorable members, let's respect the speaker at the podium, okay? Let's just respect. Order. Continue, honorable minister.
365 years of white monopoly, colonial, apartheid rule continues to sustain itself in some form or another. The majority of the indigenous people of this country are yet to realize the kind of freedom that the African National Congress, under the leadership of many of its heroes and heroines, strove for. This will only be realized when the majority of the people of this country participate in its economy, enjoy the quality of life they deserve in the same manner as their white counterparts in this country. We will only achieve this once we have finally broken the back of institutionalized racism, which continue to manifest itself in the distribution of economic opportunity and prosperity in the country. This is the real racism we need to fight and overcome in this country. And let me remind Ms. Zille that yes, in 1652, certain people arrived on the shores of this province in particular. A decade on, yes, she may have succeeded in sustaining that legacy in this province by ensuring that her black counterparts, her fellow countrymen and women, continue to be marginalized here.
Order, honorable members.
Where colonialism
Honorable Waters
found its birth.
You will whip.
But
no, honorable minister, honorable members, it won't assist the debate and the decorum of the House in the view of all these guests here if you just shout time. There's staff sitting here who is busy monitoring this debate, and really your shouting of time is not helpful towards concluding this debate in a decent manner. Let's respect ourselves and the people who are here. You must conclude now, Honorable Minister.
But let's remind Ms. Zille that 105 years ago, a province up into the inland of this country witnessed the birth of a new child called
Honorable
the
Minister,
African
your
National
time is now
Congress,
expired.
which today continue to spearhead the reversal of the legacy of colonialism and apartheid, and we will continue to pursue that
Honorable
dream
Minister.
to the end. Thank you very much.
Honorable members, that is the end of this mini plenary session, and the session is adjourned.